Hi everyone, my name is Pollock. I am an attorney who helps other attorneys engage the audiences that are vital to their firm's success, including their clients, their referral sources, their employees, and the media. In this video, running conflicts checks on your thought leadership marketing content. Yes, really, running conflicts checks on your blog posts, bylined articles, and client alerts before they're published. If you don't, you run a risk of perhaps having that content coming back to bite you and your law firm in the rear in two distinct ways. The first is through a positional conflict. Now, this is admittedly probably not likely to happen, but if it does happen, it is going to be more severe than the second issue that I'll talk about in a moment. A positional conflict happens when an attorney takes a position in a litigation that materially limits their ability or their firm's ability to represent another client in an unrelated matter. A classic example of this is when attorney A makes an argument before an appellate court regarding some case, some law that actually is inconsistent with how that attorney's colleague at their firm is arguing for another client in a separate matter at the trial court that is controlled by that appellate court. Obviously, if the first attorney prevails with the appellate court, the second attorney has a problem because now the client is on the other side, that second client is on the other side of that first attorney's argument. Positional conflicts, you can read more about that in paragraph 24 of the comment to Rule 1.7 of the ABA Model Rules of Professional Conduct. As a reminder, check your local jurisdiction to determine what that local jurisdiction has to say about conflicts of interest, but chances are good that it's going to echo the ABA Model Rule 1.7 and its comment. This positional conflict, again, it's unlikely to happen because what we're talking about here is we're talking about thought leadership marketing content. We're not talking about actually arguing in court in a way that's different than another client of the firm's. But you could see how theoretically an attorney who's writing a blog post or client alert about a new case, how if they're arguing how the case impacts clients or people moving forward, and it's in a way that's inconsistent with how the law firm is already arguing a client's case, that could pose a problem. That could pose a problem because you might have third parties, adversaries chiming in and saying, hey, there's a conflict here, and the law firm should get booted from the case and end its representation because it's taking some kind of public position that is inconsistent with how it's litigating its cases for a particular client. Again, this is probably not likely to happen, but it could happen, and that's why it's worth noting. Now, the second issue, which is not as severe as the first, but probably much more likely to happen, is reputational management issues and client service issues. If an attorney at your firm is writing about a development in the law and takes a position that's inconsistent with how the law firm is representing a current client in a pending matter. So for example, I know of firsthand a large corporate law firm that had its employee benefits group write a client alert about a recent U.S. Supreme Court case. And that decision said X. And interestingly, that analysis was not quite consistent with how the firm and different attorneys at that same firm were representing clients currently in the Second Circuit regarding a related issue. The plaintiffs in that Second Circuit case cited to the law firm's client alerts as a sword against the law firm's client that was involved in the case. This didn't cause a conflict of interest, it didn't cause a malpractice claim or anything like that, but it was very embarrassing to the law firm. So you could see how that could rub clients the wrong way, that gives ammunition to third parties and adversaries to come in and say, hey, your law firm's saying A in this case, but they just wrote this client alert, this blog post that says B. A and B are inconsistent with each other. There's something going on here. So you could see how the embarrassment would probably make it worthwhile to try and avoid that kind of conflicting position that you take in the court case versus subsequent thought leadership marketing content. So these conflicts could happen. So what's a law firm to do? My recommendation is to create some kind of conflict check system, just like you do when a new client comes in the door. Now, this system is a little bit more difficult to put into place because it's not just a matter of listing names and companies and matching to see if a law firm has an issue representing a certain party in the future based on a past client or past matter. Instead, it needs a little bit more of an active conflict check process. So in that case, I'd recommend that you have an admin, a staffer, a paralegal, marketing assistant, whomever, circulate to the attorneys of the law firm a brief email when there is a partner or associate contemplating writing about a particular topic. So you have that person write an email to the attorneys basically saying, Joe Blow wants to cover the recent 7th Circuit decision, XYZ. In X, Y, and Z, ABC happened, and Joe Blow's view is that because of ABC, that if you want to argue ABC in the future, that you're going to have this issue. Is anybody currently arguing ABC or arguing the inverse of ABC? We want to make sure that we don't get too far along in the publication or the development of this thought leadership content before we make sure that there's no one who has a conflict or has inconsistent client matters with the position that the attorney is going to take in the blog post or whatever. You email that out, and within 24 hours or so, if no one gets back to you, that's a pretty safe bet that no one has that issue. But it's the mere system, the mere ability to check that before you go down the route of creating the content and publishing it, I think is a great way to avoid these potential conflicts. Again, a true positional conflict is unlikely to happen here, but if it does, the consequences are severe. Likewise, the reputational hit or client service hit caused by this kind of conflicting marketing content is not likely to be terribly serious, but it is likely to have repercussions that could damage a relationship between you, your law firm, and a client. Thought leadership content is meant to do good. It's meant to inform the public about legal issues and legal topics. It's meant to help you and your firm bring in business and increase your revenues and profitability. It's not meant to be a problem. But if you don't have a conflict system for your thought leadership marketing content, you run the risk of that thought leadership marketing content moving from good to bad and posing problems to your firm that you probably weren't even thinking about.